It's been a busy week for the Oklahoma Supreme Court. ONR's Ed Murray reports justices heard arguments on the merits of one measure while striking down another.
It was standing room only inside the Supreme Court on Tuesday. The first hearing in the Capitol chamber since new renovations dealt with an effort to redesign the way legislative districts are drawn. From statehood until now, the legislature, like in most states, has that task every 10 years following a census. But a group wants to change that. Andy Moore is executive director of People, Not Politicians.
I think one of the worst things you can say is just because we've always done it that way, that's the way we should keep doing it. There are many things about our government we've done for far too long, and gerrymandering is one of them. It's time to end this and to change the law now.
Gerrymandering involves manipulating the boundaries to favor the party in power. Potential State Question 804 would create a non-elected commission to draw the districts. But that petition was challenged before a single signature was collected.
The key to understanding today's proceeding is it's about procedure. It's not whether this petition is a good idea or not. It's should it proceed to the ballot. One of the things we want to talk about is the single subject rule, to try to change the system for redistricting state legislators and congressional legislators. That's always been handled as two different subjects and should be again.
But the petition's attorney told justices it was very clear all provisions contained dealt with one subject, redistricting. The challenger's attorney, Robert McCampbell, also argued that several restrictions on who can sit on the commission violate First Amendment rights.
The intent of our policy is to eliminate or at least mitigate conflicts of interest that may occur for members who would serve on this commission. And our intent is not to restrict anyone's First Amendment rights. Our intent is to ensure that district lines in Oklahoma are drawn fairly and transparently, and we have crafted a policy to do just that.
Also challenged, the petition's gist, the summary that appears on the signature collection page.
Because the petition fails to provide necessary information, for example, what will the allocation of power be for the new redistricting commission, the gist cannot meet this court's requirements.
Justices question why the gist didn't mention the proposed panel structure, the role of judges in the selection process, even omitting the purpose, preventing gerrymandering.
I think the gist stands on its own. It is intended to be just that, just the gist. It's just a quick summary of the argument, and their side saying that it is too summarized is a little bit silly.
The court gave no indication when it would rule, but did reach a decision this week on a liquor law from last year's session. The justices declaring Senate Bill 608 unconstitutional because it forced wine and spirit producers of the top 25 brands to sell to all state wholesalers, violating a constitutional change passed by voters in 2016. John Meisch is president of the Institute for Responsible Alcohol Policy.
We're grateful for the court taking the time to hear the case and to render the verdict that it did.
State Question 792 allowed the sale of wine and beer in grocery and convenience stores and cold strong beer in liquor stores, and also permitted producers to enter a relationship with a single distributor.
These exclusive distribution agreements are not unique, obviously, to the liquor industry. They're in nearly every industry in the country. It's a way for manufacturers to be able to control and have input into how their product is delivered and how their product is presented.
Meisch acknowledges liquor stores have been impacted by the changes, but the industry will seek solutions that adhere to constitutional reforms.
But the legislature can make changes. They have made changes to assist. And we'll continue to work with those liquor stores as well.
By the way, the winning argument on behalf of the IRAP, attorney Robert McCampbell. One win and a no decision before the High Court this week. Ed Murray, the Oklahoma News Report.
Now, if the Supreme Court allows the petition to proceed, supporters would have 90 days to collect nearly 178,000 signatures to get the measure on the November ballot.